जब इंश्योरेंस कंपनी वकील साहब को 15-20 हजार रुपए दे सकती है तो गरीब क्लेमेंट को क्यों नहीं दे सकती? Insurance company to bear cost of this litigation for the claimant, which is certified at 25,000 rupees.
Company appeal in this case.
किस ground पर है?
इसमें workman
Minor,
compensation.
minor, there is a question of maintainability also, as they have not deposited the entire amount. That was argued earlier also, and it is mentioned in the old order.
Ground क्या है? किस ground पर है?
वाले इसमें हमारा ये कहना है कि डेट ऑफ एक्सीडेंट से जो ब्याज लगा है वो डेट ऑफ अवार्ड से लगना चाहिए।
Date of award से नहीं लगेगा।
और दूसरी
अच्छा,
चीज
बहुत
क्या
क्लियर है, 1 महीने बाद from expiry of 1 month time from the date of the accident वहां से ब्याज लगेगा। उतना दोनों की कंसेंट से मॉडिफाई कर देते हैं। That's the end of the matter।
नहीं, वही ऑर्डर है,
ये पैरा 18 से
1 माह पश्चात से लिखा तो है, वही तो लॉ है।
वही ऑर्डर है,
वही ऑर्डर है, फिर क्या दिक्कत है?
इसमें जमा कर दिया है मतलब पूरा अवार्ड।
नहीं, आपने कर दिया होगा,
जी,
अच्छा किया आपने।
जी।
लॉ क्या है? लॉ यही तो है, 1 महीने बाद से देना ब्याज, फिर बचा क्या? आपने लगाई क्यों अपील? किस प्रावधान में है कि डेट ऑफ अवार्ड से होना चाहिए? पढ़िएगा, प्रावधान पढ़िएगा।
और दूसरी चीज मान लिया इसमें 4,000 रुपए जो क्या कहते हैं इनकम मानी है विदाउट डॉक्यूमेंट के लमसम करके मान ली वाले।
हाँ,
हमारा ये कह रहा है पैरा 11 वाला।
अच्छा,
दो ही ग्राउंड है माले
जी। तो कितनी क्या इनकम आपने प्रमाणित करी? एविडेंस
इसमें 2,000 रुपए 4,000 रुपए मानते हुए।
नहीं, कहाँ एविडेंस लीड करी है आपने?
नहीं, एविडेंस नहीं आया इसमें।
फिर आपको एविडेंस लीड करने से किसने रोका था?
इसमें प्राची ने अपने कथन में बताया कि उसके पति
डेट ऑफ एक्सीडेंट क्या है?
डेट ऑफ एक्सीडेंट है 3/1/2004।
क्या करता था?
ये एक ड्राइवर था मतलब।
हाँ, तो एम्प्लॉयर ने क्या एविडेंस लीड करी है?
एम्प्लॉय वो
This
इतनी
appeal
आया
is filed on 2 grounds, namely being aggrieved of award order dated 26/6/2012 passed by Commissioner for Workmen Compensation Labour Court Jabalpur in case number 17/04/factor bracket में श्रीमती गौरी बाई widow of Gariba and others versus Mohammad Shabir Khan and another on 2 grounds, namely learned tribunal took notional income of the deceased at rupees 4,000 per month for an accident which took place on 3/1/2004,
हाँ
3/1/2004, whereas notional income for an unskilled for a driver was much less on the said date. Full stop. Second issue which has been raised herein is that the learned tribunal has awarded interest at the rate of 12% from the date of expiry of 1 month of the date of accident. Full stop. Thus, it is submitted that दुर्घटना दिनांक एक जगह 28 एक आ रही है।
हाँ, वो गलती से टाइपिंग मिस्टेक है वाले नीचे
है क्या? डेट क्या 3/1 है?
हाँ 3/1 है।
3/1/2004 है।
ये पैरा नंबर 18 में 28/1/2004 लिख गई, जबकि 3/1/2004
क्या लिखा? We should have been actually from the date of the award. Next para. Shri Chauhan supports impugned order. Next, after hearing learned counsel for the parties and going through the record, it has come on record that non-applicant number 2, that is the insurance company who has filed this appeal, did not lead any evidence, though several opportunities were given to them, as is mentioned in para 6 of the impugned order. Full stop. Did not contradict the statements given by the claimants that deceased was getting salary of rupees 4,000 per month, as is mentioned in para 11 of the impugned order, and therefore the first ground raised by learned counsel for the appellant insurance company that income of the appellant income of the deceased is disputed is not made out. Full stop. In view of the above discussion, when insurance company did not lead evidence despite affording sufficient opportunity, comma, it is not open to it now dispute the factum of income without leading any evidence in this behalf. Full stop. Next para. As far as second aspect is concerned, that is award of interest at the rate of 12%, comma, that of interest is firstly statutory, and secondly, it is to be given from the expiry of 1 month of the date of the accident or the failure of the employer oblique insurer to pay the compensation within that statutory period of 1 month, as is provided under Section 4 enjoins a responsibility on the employer oblique insurer to pay simple interest on the amount of compensation at the rate of 12% per annum or at higher rate or at such higher rate not exceeding the maximum of lending rates of any scheduled bank as may be specified by the central government, comma, by notification in the official gazette, comma, on the due amount, semicolon, and thus the interest is to be paid not from the date of award, but from the date of the accident, from the date of expiry of 1 month of the accident, because it was the responsibility of the employer to pay compensation with the commissioner or to the employee without prejudice to the right of the employee to make such further claim within a period of 30 days. And therefore, award of interest from the date of expiry of 30 days cannot be faulted with full stop. Next paragraph. As far as tribunal is concerned, it has wrongly mentioned the date of accident as 28/1/2004, whereas it is admittedly 3/1/2004. Therefore, interest will be payable from 3 February 2004 and not thereafter. Full stop. Next paragraph. With the aforesaid modification, appeal is disposed of. Since the insurance company has failed to make out any ground to substantiate the grounds raised by them in this memo of appeal, appeal fails and is dismissed, insurance company to bear cost of this litigation for the claimant, which is certified at 25,000 rupees and which will be payable to the claimant in addition to the amount so awarded.
Well, cost of
आप फ्रिवलेस अपील लगाओगे तो ये सब मिलेगा। अब इंश्योरेंस कंपनी वकील साहब को 15-20 हजार रुपए दे सकती है तो गरीब क्लेमेंट को क्यों नहीं दे सकती?